Good afternoon, everyone, and welcome. Thank you for joining us for which is, believe it or not, episode 18 of Stewarts Soundbites. For those of you wondering who I am, my name is Nikki Maple-Pearson, and today we have a bit of a switch around, as I am your host and have the absolute privilege of speaking to Emma Lyons, the very founder of Stewarts Soundbites. As most of you all know, Emma is an associate in the PI team in Leeds, and she has been nothing short of instrumental in the production of these webinars. Today marks the penultimate part of a 4-part mini-series discussing the key stages of the litigation process in a catastrophic injury claim. I'll be speaking to Emma about what happens after court proceedings are issued and the importance of witness and expert evidence, schedules of loss, and onto the all-important settlement or failing that trial. But I'm always told we have so little time and so much to cover. So Emma, hi.
Hello, Nikki.
It must be so strange being hosted and not hosting for a change.
Yeah, it's really, really weird. It's kind of relaxing, but also terrifying at the same time. But I'm ready. I'm ready.
You're ready. Okay, so probably the first big question that comes to mind is, what are the main reasons that court proceedings are issued, and how does it ultimately change things in a case?
So court proceedings, I mean, the simplest reason that we end up issuing court proceedings on a case is that limitation is approaching. So you've got that magic 3 years from the date of the accident in which you have to issue proceedings. Now, generally speaking, it's 3 years from the date of the accident. There are, of course, exceptions to that. For example, if your client lacks capacity, then the clock doesn't start ticking until your client regains capacity. And if they don't regain capacity at all, then the clock doesn't start. Mm-hmm. For children, it's 3 years from the date of their 18th birthday. If your client sadly dies during the course of litigation, then it's 3 years from the date of death. Believe it or not, at sea and in the air, there are different timescales as well. Generally speaking, it's 2 years, but I mean, that's an entirely different episode. But that is one of the main reasons that we issue court proceedings. Other reason might be that we have a firm denial of liability, and we're not going to get anywhere with the defendant without issuing court proceedings. And the last most common reason that we issue court proceedings is if you want something specific. So if a claimant is, for instance, in desperate need of rehabilitation and the defendant are refusing an interim payment, then you can issue court proceedings and make an application to the court that they order an interim payment. In terms of how it changes things, I think sometimes there's an expectation that when we issue court proceedings, there's this kind of mad flurry of activity and everything goes into, warp speed. And that's not the case initially, because we've got to serve the documents, which isn't always done as soon as we issue. We've got to wait for an acknowledgement of claim. There's got to be a defence. Defendants inevitably request an extension to file their defence. The court lists a hearing in which they manage the case, set a timetable and budget costs if that's relevant. So it takes a little bit of time, but the main thing is that there's that timetable in place. From a client's perspective, nothing really changes that much, hopefully. Of course, some clients experience a bit of anxiety with court proceedings because they think, oh my goodness, my case is kind of hurtling towards a trial. And that's not normally the case, but the most important thing for the legal team and experts, case managers, treating team, everyone on the team to be aware of it is that we now have a timetable in place which has very, very strict deadlines for exchange of evidence and all sorts of exciting things, and everyone needs to be really conscious of that. There's also a bit more pressure on settlement. I think after court proceedings are issued, because the costs go up so much, and it tends to focus the parties' minds, I think, a bit more on resolution of the case if that's possible.
Yeah, and one of the things that I know that obviously happens after the issue of court proceedings is the requirement by the court to file and serve witness evidence. So that's obviously that leads me on to sort of my next question. I guess my question is, how important is witness evidence in a catastrophic injury claim? Who do we need it from? And do you have, from your experience, any top tips for those people involved in cases who perhaps frequently draft their own statements, such as case managers, for example?
Yeah, we love top tips in Stewarts Soundbites, so I'll definitely have some of those. No one is going to be surprised when I say that witness evidence is vital in these cases. Most of the time, a person's witness statement is their evidence in chief, and if we end up at trial, all of the questions that are asked, all the cross-examination is all based upon the witness statements. Generally, it's not possible for new matters to be introduced at trial, so it's really important that everything is covered in statements. Much can turn on witness statements. I mean, oftentimes, we did a trial last year and there was a dispute as to a fact. Was X person, did X person do Y on the day of the accident? You've got one side saying, yes, yes, I did, and the other side saying, no, no, you didn't. And the judge is going to look at the witness statements and the evidence given in court by those two witnesses and make a decision. So it's really crucial. And witness evidence is also important to demonstrate need. So for instance, if there's an extensive care regime in place, it's really important to clearly cover what is required, when it was implemented, how successful it was, any trials, anything that hasn't worked, all of that stuff needs to be covered in detail. As to who provides witness evidence, it depends whether we're talking about liability evidence. If we are, then if the claimant can remember the accident, then they provide evidence. The police, any witnesses to the accident, anybody in connection with any investigation in relation to the accident. Quantum, those statements tend to be meatier and longer in the types of cases that we deal with, and those statements generally come from the claimant, their family, their friends, their carers, their case managers, any of the treating team if there's a specific issue that needs to be addressed, employers, colleagues, anybody that has something substantive to contribute to the case and that is important. The last part of your question was about tips. So the best piece of advice that I was ever given when I was a very junior lawyer was prepare your case, every bit of your case, as if you know you're going to end up in front of a judge. A judge is going to scrutinize what you have prepared and ask questions. You're going to be questioned on it. So I think the best tip is always think about the judge. What does the judge want to see? They only want to see what is relevant. They've got to make decisions about the case. So what can you add? There's nothing like, talking from experience, there's nothing like sitting in court, listening to witnesses being cross-examined and answer questions that focuses your mind on what needs to be in that statement. It should be drafted in your own words entirely. You can ask your solicitors for guidance and for help, but it should be in your own words. Only say what you know. If you don't know something, just say, I don't know. Acknowledge that there's a question mark over something. Do not give your opinion, and that's really hard, actually. It's really hard, but the court are only interested in facts. In terms of format, I'm a big fan of headings. I'm a fan of bullet points where they're appropriate. To try and address everything in chronological order is preferable because it flows and it makes sense and it helps you kind of recall everything as it happened and set out how you got to where you are. And just be brief where you can. If you only need a paragraph to say something, don't spend 2 or 3 pages on it. Mm-hmm. Remember that you've got to sign a statement of truth at the end.
Well, thanks so much. Those tips will be really helpful, I think. I think one of the most natural questions that a client asks their lawyer is, will I have to go to court? And I think it generates a very natural sense of anxiety, the thought of having to go to court and be in front of a judge, and perhaps if they haven't done it before. I'm just interested how many cases actually reach trial, and what's the process of getting there?
Well, the first thing to say, Nick, is you're absolutely right. Most clients ask us in the first meeting or two, am I going to have to go to court? Am I going to have to give evidence? And they imagine themselves being cross-examined in the way that we see criminal defendants being cross-examined on all of these TV shows and The Good Wife, and it's terrifying. And whilst we try really hard to allay those fears, sitting in front of a judge in a courtroom is, in an adversarial setting, is very intimidating. And we can never say to a client, no, you won't need to go to court, we're going to get this all settled for you. We can never guarantee that. What we can say is actually only about 5% of these cases ever reach trial. And the reason that is because solicitors very carefully risk assess these cases and consider the prospects of success. So only the cases that are likely to be successful will proceed. Obviously, it's never guaranteed. And also, it's an expensive process. You know, once court proceedings are commenced, it becomes very expensive, and defendants tend to be more focused upon settlement, but both parties do. The process is led by the court from the date of issue. It's very rare that we'll get to a trial any sooner than a year to 18 months. The run up to the trial is frantic for the solicitors. Hopefully the client isn't impacted by that. The length of the trial will either be ordered by the court or agreed between the parties at an early stage. But for a quantum and liability trial, you're probably looking at 10 days in one of these big cases. The trial itself, I mean, I could go on about this for ages, but we're short on time. So we've got, you know, the claimant presents their evidence, the defendant presents their evidence, the experts are called, only the key witnesses are called. It's different because in the US we see on these TV shows, maybe I'm showing how much American kind of legal TV I watch, but you know, you see that their professional rules typically permit coaching of witnesses. So you'll see them in their conference room telling their clients what to say, whereas the rules in England and Wales are much tougher, and the conventional line is that lawyers can familiarise their witnesses with the process but not coach them on the content, and that we're very, you know, that's really strict. And in reality, during the trial, you kind of don't really have anything to do with your witness until they've given their evidence afterwards. So that's I know that was kind of a flash, but that's all we've got time for.
Absolutely. So if a case obviously settles before trial, what are the sort of the alternative means by which that can happen?
So there are now lots of different types of ways cases can settle. There's lots of different means of alternative dispute resolution, as we call it. I think the legal profession has evolved and become a bit more creative and sophisticated in how they deal with these cases. Everybody knows what a joint settlement meeting is, so I'm not going to go over that. We all know, but there are other options. There's mediation, which is commonly used actually in family law matters where you have an appointed independent mediator. That process tends to be legally binding. It's quite expensive. A mediator is a facilitator. They're not interested really in coming to a decision upon the issues in the case, but rather kind of facilitating a discussion between the parties. Early neutral evaluation is something else which is not as common. It's actually mentioned in the CPR, and it says that the court can take any other step or to make any other order for the purposes of managing the case, including hearing an early neutral evaluation. And this is where an independent party evaluates the case at an early stage and expresses a preliminary view upon the case. That can take place before proceedings, during proceedings, and that sets the scene for negotiations. And whilst mediation, as I mentioned, isn't particularly concerned with considering the merits of a case, that lies at the very heart of early neutral evaluation. And that's useful in cases where you've got completely opposite views on liability. It's indicative, it's not binding. And finally, arbitration, which is basically more formal than mediation. You refer your case to a neutral party for a binding decision. And in reaching this point in all cases, what's really important is to have together, unless you're only discussing liability and you just know that there's not going to be any conversation about settling the entire claim, then you should have a schedule of loss And in terms of what clients can do, what the team can do for that, keep receipts, keep a diary. You know, as solicitors and case managers, all of the team should be aware, family and friends, keeping a diary of the care that providing, expenses that are incurred is so important. And again, it's that try before you buy. You know, try as much as you can that you want to be costed into the future in order for it to feature in the claim.
Yeah, great advice, Emma. And finally, I think we've probably got time for one more question. When a case does settle, by whichever means it does, is that it, or are there any other threads that need to be tied up?
Sadly, there are threads that need to be tied up. So being a personal injury lawyer is funny because people never want to have to use you for obvious reasons. When they do have to use you, they rely on you intensely. It's you know, a relationship builds, but at the same time they can't wait to never have to speak to you again, so that kind of chapter on their life is closed. And the stress, I suppose, at the settlement of a case, the stressful bit for the client is usually over. It usually marks a type of closure for them, but sometimes it can be difficult because you spent a long time talking to these people and building relationships and, you know, providing advice along the way. So for some clients, it takes a little bit of adjusting. It also takes a while for any compensation to come in. And again, it depends on what the compensation, how that the form of the award. So if it's a lump sum, or whether part of it is going to be paid on an annual basis by way of periodical payment. So it doesn't happen overnight. We don't agree a settlement and then have money in the bank the next day. And of course, with clients who lack capacity, you've got to have the case approved by a court, and that usually takes a few months, all being well. Costs also need to be negotiated. And during that time, unfortunately, we're still pestering clients for instructions, and that cost negotiation can sometimes result in a little bit of money being tied up, or it depends on each case. But for a client, it's difficult because they're feeling their way after the settlement of their case, and they're starting to think about, what's my situation now? Can I buy a house? And can I do X, Y, and Z that I want to do? And it's overwhelming. And one thing that they've got to do is think about financial advice. And the answer for every client is different, but it often involves a combination of investment, family care and support, maximising and kind of maintaining statutory benefits, care funding and compromises and all that sort of stuff. So that's something else for the clients to think about. And I suppose provisional compensation is a rare exception to the finality of these cases. So they might be awarded if the court feels that there's a real risk that the client could develop a significant deterioration in their health. So there will be permission for a client to apply to the court if that risk identified is realised. And I realise that I've gone over time, which is so not like me. And this has been a Whistle Stop tour. So if anyone has any questions about anything that I've really quickly rushed through, please just email me.
I can't believe how quickly 15 minutes goes. It just, well, 18 minutes now. But I mean, thank you, Emma, for all your insight today. It's, you know, you've been brilliant, as always. Just for everyone watching, next week, episode 19 is Chris Smith. We'll be completing our mini-series, talking to a former client of his, Steve Cook, and his wife about the litigation process through the eyes of the claimant and their family, so a slightly different perspective. And finally, just a shameless plug, if anyone's at a loose end this afternoon and they would like to attend the amputee seminar being hosted by Nikki Fosler, there's still time to register, and all of the details are on the Stewarts website. Thank you so much for watching, and thank you, Emma.
Thank you so much. Take care.
Bye.
Bye.